Is publication needed? Tañada versus Tuvera. The clause "unless it is otherwise provided" refers to the date of effectivity, and not to the requirement of publication itself, which cannot in any event be omitted. This clause does not mean that the legislator may make the law effective immediately upon approval, or on any other date without its previous publication. Publication is indispensable in every case, but the legislature may in its discretion provide that the usual 15-day period shall be shortened, or extended. What needs to be published? 1. All statutes, including those of local application and private laws, shall be published as a condition for their effectivity, which shall begin 15 days after publication unless a different effectivity date is fixed by the legislature. 2. Presidential decrees and executive orders promulgated by the President in the exercise of legislative powers whenever the same are validly delegated by the legislature or, at present, directly conferred by the Constitution. 3. Administrative rules and regulations, if their purpose is to enforce or implement existing law pursuant also to a valid delegation. 4. The charter of a city, notwithstanding that it applies to only a portion of the national territory and directly affects only the inhabitants of that place. 5. All presidential decrees, including even, say, those naming a public place after a favored individual or exempting him from certain prohibitions or requirements. 6. The circulars issued by the Monetary Board, if they are meant not merely to interpret, but to fill in the details of the Central Bank Act which that body is supposed to enforce. When publication not required. 1. Interpretative regulations and those merely internal in nature, that is, regulating only the personnel of the administrative agency, and not the public. 2. Letters of instructions issued by administrative superiors concerning the rules or guidelines to be followed by their subordinates in the performance of their duties. 3. Instructions issued by, say, the Minister of Social Welfare on the case studies to be made in petitions for adoption, or the rules laid down by the head of a government agency on the assignments or workload of his personnel or the wearing of office uniforms. 4. Municipal ordinances are not covered by this rule but by the local government code. The publication must be in full or it is no publication at all, since its purpose is to inform the public of the contents of the laws. Farinas versus Executive Secretary. The Effectivity Clause, Section 16 of Rep. Act No. 9006, which provides that it shall take effect immediately upon its approval, is defective. Following Article 2 of the Civil Code and the doctrine enunciated in Tañada, Rep. Act No. 9006, notwithstanding its express statement, took effect 15 days after its publication in the Official Gazette or a newspaper of general circulation. Effectivity of the Civil Code. This code shall take effect 1 year after such publication. Lara versus Del Rosario. August 30, 1950, when the new Civil Code went into effect, that is, 1 year after its publication in the Official Gazette.